May it please the tribunal, the U.S. prosecution now passes into the aggressive war phase of the case, and it will be presented by Mr. Alderman. Mr. Alderman.
May it please the tribunal. I rise to present on behalf of the United States Chief of Counsel evidence to support the allegation of count 1 of the indictment relating to the planning, preparation, initiation, and waging of illegal and aggressive war, and relating to the conspiracy to commit that crime. The aggressive war phase of the case, the aggressive war phase of the conspiracy case under count 1, and the aggressive war phase of the entire case is really, we think, the heart of the case. If we did not reach it in our presentation, we would not reach the heart of the case. If we did not present it to the tribunal in the necessary detail, we would fail to present what is necessary to the heart of the case. After all, everything else in this case, however dramatic, however sordid, however shocking and revolting to the common instincts of civilized peoples, is incidental to or subordinate to the aggressive war aspect of the case. All the dramatic story of what went on in Germany in the early phases of the conspiracy, the ideologies used, the techniques of terror used, the suppressions of human freedom employed in the seizure of power, and even the concentration camps and the crimes against humanity, the persecutions, tortures, and murders committed, all of these things would have little juridical international significance, except for the fact that they were the preparation for the commission of aggressions against peaceful neighboring peoples. Even the aspects of the case involving war crimes in the strict sense are aspects which are merely the inevitable proximate result of the wars of aggression launched and waged by these conspirators, and of the kind of warfare they waged, that is, total war, the natural result of the totalitarian party-dominated state that waged it, and atrocious war, the natural result of the atrocious doctrines, designs, and purposes of these war makers. For these reasons, I repeat, that in our view, the phases of the case dealing with territorial gains acquired by threats of force and with actual aggressions and aggressive wars constitute the real heart of the case. Accordingly, we ask the indulgence of the tribunal if for these reasons we make the presentation of this part of the case as detailed as seems to us necessary in view of the outstanding importance of the subject matter. The general scope of the case to be presented by the American prosecution has been stated in the opening address by Mr. Justice Jackson. That address indicated to the tribunal the general nature and character of the evidence to be offered by the American prosecution in support of the allegations with which I shall deal. However, before approaching the actual presentation of that evidence, it seems to us that it would be helpful to an orderly presentation of the case to address the tribunal in an introductory way concerning this specific segment of the prosecution's case. In doing so, I shall not attempt to retrace the ground so ably covered by Mr. Justice Jackson. On the contrary, I shall confine my introductory remarks to matters specifically and peculiarly applicable to that part of the American case relating to the crime of illegal warfare and the common plan or conspiracy to commit that crime. The substantive rule of law which must guide the consideration of the tribunal on this aspect of the case, and the rule which must be controlling in the final judgment of the tribunal on this part of the case, is stated in Article 6 of the Charter of the International Military Tribunal. Article 6, so far as pertinent here, reads as follows. The tribunal established by the agreement referred to in Article 1 hereof for the trial and punishment of the major war criminals of the European Axis countries shall have the power to try and punish persons who, acting in the interests of the European Axis countries, either as individuals or as members of organizations, committed any of the following crimes. The following acts, or any of them, are crimes coming within the jurisdiction of the tribunal for which there shall be individual responsibility. A, crimes against peace, namely planning, preparation, initiation, or waging of a war of aggression or a war in violation of international treaties, agreements, or assurances, or participation in a common plan or conspiracy for the accomplishment of any of the foregoing. Subparagraphs B and C of Article 6 are not pertinent to this aspect of the case. However, the unnumbered final paragraph of Article 6 is of controlling importance on this aspect of the case. That paragraph reads, leaders, organizers, instigators, and accomplices participating in the formulation or execution of a common plan or conspiracy to commit any of the foregoing crimes are responsible for all acts performed by any person in execution of such plan. In receiving evidence on this aspect of the case, I would request the tribunal to have in mind 5 principles derived from the portions of the charter I have just read. First, the charter imposes individual responsibility for acts constituting crimes against peace. Second, the term crimes against peace embraces planning, preparation, initiation, or waging of illegal war. Third, the term crimes against peace also embraces participation in a common plan or conspiracy to commit illegal war. 4, an illegal war consists of either a war of aggression or a war in violation of international treaties, agreements, or assurances. These 2 kinds of illegal war might not necessarily be the same. It will be sufficient for the prosecution to show that the war was aggressive, irrespective of breach of international treaties, agreements, or assurances. On the other hand, it would be sufficient for the prosecution to show that the war was in violation of international treaties, agreements, or assurances, irrespective of whether or not it was a war of aggression. We think the evidence in this case will establish conclusively that the wars planned, prepared, initiated, and waged by these defendants, and the wars which were the object of their common plan and conspiracy, were illegal for both reasons. The 5th principle, which I ask you to bear in mind, is that individual criminal responsibility of a defendant is imposed by the Charter not merely by reason of direct, immediate participation in the crime. It is sufficient for the prosecution to show that a defendant was a leader, an organizer, instigator, or accomplice who participated either in the formulation or in the execution of a common plan or conspiracy to commit crimes against peace. In the case of many of the defendants, the evidence will show direct and immediate personal participation in the substantive crime itself. In the case of some of the defendants, the evidence goes to their participation in the formulation and execution of a common plan or conspiracy. In the case of each defendant, we think, the evidence will establish full individual responsibility for crimes against peace as defined in the charter of this tribunal. In this connection, I wish to emphasize that the charter declares that the responsibility of conspirators extends not only to their own acts, but also to all acts performed by any persons in execution of the conspiracy. It is familiar law in my country that if two or more persons set out to rob a bank in accordance with a criminal scheme to that end, and in the course of carrying out their scheme, one of the conspirators commits the crime of murder, all of the participants in the planning and execution of the bank robbery are guilty of murder, whether or not they had any other personal participation in the killing. This is a simple rule of law declared in the charter. All the parties to a common plan or conspiracy are the agents of each other, and each is responsible as principal for the acts of all the others as his agents. So much for the terms of the charter having a bearing on this aspect of the case. I invite the attention of the tribunal to the portions of the indictment lodged against the defendants on trial which relate to the crimes of illegal war or war of aggression. Particularly, I ask the tribunal to advert to the statements of offense under count 1 and count 2 of the indictment in this case. The statement of offense under count 1 of the indictment is contained in paragraph Roman 3. The offense there stated, so far as pertinent to the present discussion, is all the defendants, with divers other persons, during a period of years preceding 8 May 1945, participated as leaders, organizers, instigators, or accomplices in the formulation or execution of a common plan or conspiracy to commit or which involved the commission of crimes against peace as defined in the charter of this tribunal. The common plan or conspiracy embraced the commission of crimes against peace in that the defendants planned, prepared, initiated, and waged wars of aggression, which were also wars in violation of international treaties, agreements, or assurances. The statement of offense under count 2 of the indictment is also relevant at this point. It must be obvious that essentially counts 1 and 2 interlock in this indictment. The substance of the offense stated under count 2, paragraph Roman 5 of the indictment is this: all the defendants with divers other persons during a period of years preceding 8 May 1945 participated in the planning, preparation, initiation, and waging of wars of aggression, which were also wars in violation of international treaties, agreements, and assurances. The emphasis in the statement of offense under count 1 of the indictment is on the common plan or conspiracy. The emphasis under count 2 of the indictment is on the substantive crimes to which the conspiracy related and which were committed in the course of and pursuant to that conspiracy. I should hasten to add at this point that in the division of the case as between the chief prosecutors of the 4 prosecuting governments, primary responsibility for the presentation of evidence supporting count 1 has been placed on the American prosecutor, and primary responsibility for the presentation of the evidence supporting count 2 of the indictment has been placed on the British prosecutor. But as we shall show somewhat later, there will to some extent be a cooperative effort as between the 2 prosecutors to present certain phases of both counts together. In addition to the statement of offense relating to illegal war in paragraph Roman 3 under count 1 of the indictment, count 1 also contains what amounts to a bill of particulars of that offense, insofar as those particulars relate to illegal war. They are contained in paragraph Roman 4F of the indictment, which is set out in the English text on pages 7 through the top of page 10, under the general heading, Utilization of Nazi Control for Foreign Aggression. The allegations of this bill of particulars have been read in open court in the presence of the defendants, and the tribunal, as well as the defendants, are certainly familiar with the contents of those allegations. I call attention to them now, however, in order to focus attention on the parts of the indictment which are relevant in consideration of the evidence which I intend to bring before the tribunal. My introduction to the presentation of evidence in this matter would be faulty if I did not invite the tribunal to consider with me the relationship between history and the evidence in this case. Neither counsel nor tribunal can orient themselves to the problem at hand. Neither counsel nor tribunal can present or consider the evidence in this case in its proper context. Neither can argue or evaluate the staggering implications of the evidence to be presented without reading that history against the reading that evidence against the background of recorded history. And by recorded history, I mean the history merely of the last 12 years. Justice Oliver Wendell Holmes of the United States Supreme Court found in his judicial experience that a page of history is worth a volume of logic. My recollection is that he stated it perhaps better earlier in the preface to his book on the common law, where he said, I think, the life of the law has been not logic, but experience. I submit that in the present case, a page of history is worth 100 tons of evidence. As lawyers and judges, we cannot blind ourselves to what we know as men. The history of the past 12 years is a burning, living thing in our immediate memory. The facts of history crowd themselves upon us and demand our attention. It is common ground among all systems of jurisprudence that matters of common knowledge need not be proved, but may receive the judicial notice of courts without other evidence. The charter of this tribunal, drawing on this uniformly recognized principle, declares in Article 21, the tribunal shall not require proof of facts of common knowledge, but shall take judicial notice thereof. The facts of recorded history are the prime example of facts of common knowledge which require no proof. No court would require evidence to prove that the Battle of Hastings occurred in the year 1066, or that the Bastille fell on the 14th of July, 1789, or that Tsar Alexander I freed the serfs in 1863, or that George Washington was the first president of the United States, or that George III was the reigning king of England at that time. If I may be allowed to interpolate, an old law professor of mine used to present the curiosity of the law that a judge is held to responsibility for no knowledge of the law whatsoever. A lawyer is held to a reasonable knowledge of the law, and the layman is held to an absolute knowledge of all the law. It works inversely as to facts or facts of common knowledge. There, the judge is imputed to know all of those facts. However many of them he may have forgotten as an individual man. So one of the purposes of this presentation will be to implement the judicial knowledge which by hypothesis exists and which probably actually exists. It is not our purpose, however, to convert the record of these proceedings into a history book. The evidence which we offer in this case is evidence which, for the moment, has been concealed from historians. It will fill in recorded history, but it must be read against the background which common knowledge provides. The evidence in this case consists primarily of captured documents. These documents fill in the inside story underlying the historical record which we all already knew. This evidence which we will offer constitutes an illustrative spot check on history, on the history of the recent times as the world knows it. The evidence to be offered is not a substitute for history. We hope the tribunal will find it to be an authentication of history. The evidence which we have drawn from captured documents establishes the validity of the recent history of the past 12 years, a history of many aggressions by the Nazi conspirators accused in this case. As I offer to the tribunal document after document, I ask the court to see in those documents definite additions to history. The addition of new elements long suspected and now proved. The elements which the captured documents on this particular aspect of the case will add to recorded history are the following. First, the conspiratorial nature of the planning and preparation which underlay the Nazi aggressions already known to history. Two, the deliberate premeditation which preceded those acts of aggression. Three, the evil motives which led to the crimes. Four, the individual participation of named persons in the Nazi conspiracy for aggression. Five, the deliberate falsification of the pretexts claimed by the Nazi aggressors as the reason for their criminal activities. These elements the captured documents will demonstrate beyond possible doubt. And these elements, in the context of historical facts, we think are all that need to be shown. The critical period between the Nazi seizure of power and the initiation of the first war of aggression was a very short period. This critical period of lawless preparation and illegal scheming, which ultimately set the whole world aflame, was unbelievably short. It covered only 6 years, 1933 to 1939. The speed with which all this was accomplished evidences at once the fanatical intensity of the conspirators and their diabolical efficiency. Crowded into these 6 short years is the making of the greatest tragedy that has ever befallen mankind. A full understanding of these 6 years and of the vibrant 6 years of war that followed demands that we see this period of time divided into rather definite phases. Phases that reflect the development and execution of the Nazi master plan. I suggest that the tribunal, as it receives evidence, fit it into 5 phases. The first was primarily preparatory, though it did involve overt acts. That phase covers roughly the period from 1933 to 1936. In that period, the Nazi conspirators, having acquired governmental control of Germany by the middle of 1933, turned their attention toward utilization of that control for foreign aggression. Their plan at this stage was to acquire military strength and political bargaining power to be used against other nations. In this, they succeeded. The second phase of their aggression was shorter. It is rather interesting to see that as the conspiracy gained strength, it gained speed. During each phase, the conspirators succeeded in accomplishing more and more in less and less time, until toward the end of the period, the rate of acceleration of their conspiratorial movement was enormous. The second phase of their utilization of control for foreign aggression involved the actual seizure and absorption of Austria and Czechoslovakia in that order. By March, the third month of 1939, they had succeeded in that phase. The third phase may be measured in months rather than years. From March 1939 to September 1939, the previous aggression being successful, having been consummated without the necessity of resort to actual war, the conspirators had obtained much desired resources and bases and were ready to undertake further aggressions by means of war if necessary. By September 1939, war was upon the world. The fourth phase of the aggression consisted of expanding the war into a general European war of aggression. By April 1941, the war, which had theretofore involved Poland, the United Kingdom, and France, had been expanded by invasions into Scandinavia, into the Low Countries, and into the Balkans. In the next phase, the Nazi conspirators carried the war eastward by invasion of the territory of the Union of Soviet Socialist Republics, and finally, through their Pacific ally, Japan, precipitated the attack on the United States at Pearl Harbor. The final result of these aggressions is fresh in the minds of all of us. I turn now to certain outstanding evidence at hand. While on this phase of the case we shall not rest exclusively on them alone, the essential elements of the crime, which I have already pointed out, can be made out by a mere handful of captured documents. My order of presentation of these will be first to present one by one this handful of documents. Documents which prove the essential elements of the case on aggressive war up to the hilt. These documents will leave no reasonable doubt concerning the aggressive character of the Nazi war or concerning the conspiratorial premeditation of that war. Some of this group of documents are the specific basis for particular allegations in the indictment. As I reach those documents, I shall invite the attention of the tribunal to the allegations of the indictment which are specifically supported by them. Having proved the corpus of the crime in this way, I will follow the presentation of this evidence with a more or less chronological presentation of the details of the case on aggressive war, producing more detailed evidence of the relevant activities of the conspirators from 1933 to 1941. The documents which we have selected for single presentation at this point, before developing the case in detail, are 10 in number. The documents have been selected to establish the basic facts concerning each phase of the development of the Nazi conspiracy for aggression. Each document is conspiratorial in nature. Each document is one I believe, heretofore unknown to history, and each document is self-contained and tells its own story. Those are the three standards of selection which we have sought to apply. This is the period covered by paragraphs 1 and 2 of section Roman 4F of the Indictment, to be found at page 7 of the printed English text. The essential character of this period was the formulation and execution of the plan to rearm and to reoccupy and fortify the Rhineland in violation of the Treaty of Versailles and other treaties, in order to acquire military strength and political bargaining power to be used against other nations. The tribunal, please, we have what have been referred to as document books. They are English translations of German documents, in some cases, German versions. I shall ask that they be handed up, and we will hand one copy at the moment to counsel for the defendants. It has been physically impossible to prepare 21 sets of them. If possible, we shall try to furnish further copies to the defendant.